Yo, it's JP. I'm going to give you a great piece of advice for anyone who is going through an employment case. And that could be a discrimination case. It could be retaliation, sexual harassment, sexual assault, workplace violence, unpaid wages. It could even be defending a bogus non-compete case that was filed against you, because we cook in all these different areas. We represent executives and employees in all these different types of cases. And out of hundreds of cases and more than 1,000 disputes, one of the best pieces of advice is this: you have to help yourself. You have to take steps to protect your own rights, to advance your own cause, to help build your own case. You have to advocate for yourself. You have to self-advocate. You have to be a good advocate for yourself, and you have to be your best ally. Because even if you get an attorney, even when you get an attorney, assuming you get one, you're going to put yourself in a better position and enable that attorney to truly step in, take the reins, and help advance your case from there across the finish line. So let's unpack this. A lot of people show up. They send an email, they call on the phone, they submit an inquiry about their case or their situation. And it's pure chaos. It's pure chaos. And sure, there's folks who are, they're not particularly educated. They don't have the best writing skills. Like, sure, and I'm empathetic to that. Okay, and we try to help people as best as possible, but we do have to be real about this, where there have to be reasonable limits and parameters on this. One of the things I see a lot of the times is I see folks, submitting these 2, 3, 4, 5, 6 page single space screeds where it's just this rant about everything, and it goes 27 different directions, and a lot of it is just naked emotion, right? Just raw emotion. It's trauma, it's hurt, it's anger, it's upsetness, okay? And yes, that may be, and that is one thing, but we have to be real about what this is, okay? I am not a social worker. I am not a psychologist. I am not a therapist. I'm a lawyer, and I solve these particular types of problems. I litigate this particular type of case. That's the tools I have. That's what I do. That is the resolution that I seek to obtain. That's what I do. That's my toolkit. Okay? And there are many instances in which lawyers such as myself, we have to at times operate not just as a lawyer, but we have to, be, supportive and help people work through these issues. But at the end of the day, that's a separate thing, that's a separate thing. So a lot of folks show up and it's over the top. It's many pages. It's hyper emotional. And then when you're trying to rein it in, when you're trying to hone in and focus on, the specifics, the concrete allegations, the facts, the who, what, where, when, why, how, they struggle to boil it down to the core specific facts. Because at the end of the day, these cases are about facts. Yes, things happen that impact people. They impact people's jobs, their lives, their families, their housing situation, their health, their psychological well-being, everything. Yes, all of that is true. But at the end of the day, these cases hinge on facts. So I'm going to start right there, because that is a very important place to start. Facts. You can help yourself. You can advocate for yourself. You can better advance your own cause or case by starting right there with facts. You boil it down. You put together an executive timeline. You put together a summary. You do a bullet list. We're not talking about 5 pages of everything in the kitchen sink and all the emotions and every single conversation that was had in the history of the 7-year tenure at the company. No. That is not reality. That is not reality. And for some people, maybe sitting down and writing all that out is cathartic, right? Where they feel like they're getting a weight off of their chest. But again, this is being real about things and not being fluff. There's a lot of people in society who tell you what you want to hear, okay? They engage in bullshit, fluff, pleasantries, okay? And they do that for a variety of reasons. One, they do that because they're uncomfortable with conflict, number one. And number two, because they want something from you, want your business, etc. Well, I don't check either of those boxes because I'm perfectly fine with conflict and I don't really care about anybody's business, okay? I have plenty of it. So the reality is, if you want to write out a 10-page, just pour it all on the paper to get it out and get it off your chest, that's one thing. But that's not what you show up and give to an attorney who you are seeking to help with your case. You do an executive summary, bullet list, timeline, who, what, when, where, why. Here's the key players. In connection with that sort of a narrative, you put together the relevant documents. And the relevant documents are going to basically be the same documents in any case. They're going to be employment agreements, any employment agreement you signed, anything that's a contract with the company, any arbitration policy, any confidentiality agreement, any handbook, anything you signed vis-a-vis the company, where it's you on one side, the company on the other side. That's pertinent for a variety of reasons. Most significantly, that could dictate where a possible case would need to be filed and what the choice of law would be. Choice of law meaning what relevant law is going to govern the dispute, because you have federal claims in many instances, but you also have state claims. So what are we talking here? Are we talking Florida law, New York law, Delaware law, California law, Illinois law? Makes a huge difference, okay? So you want to put that together. You got your factual timeline in a format that is, one, efficient, okay? It's efficient. That means short, to the point, easy to read, understand, digest, because that's the point of it, okay? The point is not, oh, I poured it all out on paper and now I feel better. That's for you, okay? That's for you, and that helps you in a certain way emotionally, but that does not help you advance your case. I'm talking about how you advance your case, okay? So it's efficient, it's easy to digest and understand. Then you have your documents, starting with the contracts, okay? Contracts, agreements, handbook. Then from there, you want pay stubs. Why is pay stubs important? Well, because pay stubs in many of these cases are going to be used to calculate certain of your damages: back pay, front pay, lost wages, unpaid overtime, etc., etc. So then you want some pay stubs in the packet. The next thing you want in the packet are pieces of evidence, okay? Significant pieces of evidence. What is likely to fall into that category? Performance reviews. That comes up in almost every one of these types of cases. Not the non-compete cases, but any of the discrimination, retaliation, sexual harassment, etc. Those cases, performance reviews always come up. So if you have formal performance reviews or even informal ones where a manager, supervisor, etc. sent you an email giving you certain feedback, you want to include that. What else do you want to include? We see it all the time. Text messages, right? If there are text messages or emails or other documents that are relevant to the claims at issue. Like, we see it in, for instance, retaliation case, okay, where somebody complains about racism and then subsequently, oh, well, look, they had good performance up until this point. They got a raise, they got a promotion, they complain about egregious, ugly, violent, hateful, good old-fashioned Confederacy racism, and then all of a sudden they're persona non grata and their performance reviews go to hell. And say there's a text message there. Say there's a text message from some mid-level manager being like, yeah, man, I know exactly what's going on here. Like, ever since you reported that racism to HR, like, there's a target on your forehead, right? Like, I've seen that case, okay? That text message where the guy, the mid-level manager, is just, right, flapping his gums and not really paying attention or understanding, just talking candidly, being honest, like fast and loose with it. And the company hasn't gotten to him yet to button him up and tell him to shut his mouth and stay off paper, right? Because that's what happens in these cases a lot of times where, these big companies especially, there'll be all kinds of shenanigans. There'll be discrimination, retaliation, sexual harassment, whatever. And before legal gets involved, before they hear from someone like me, before there's a EEOC charge filed or a demand letter sent or a lawsuit filed, before that happens and before legal gets involved, there's all kinds of text messages, emails, documentation. And that's often really valuable, really fruitful, productive evidence, because that's before legal has buttoned it up. Like, legal's going to come in at some point and basically say, hey, everybody, keep it out of writing, okay? Don't put anything in writing. Don't put anything in text message or email or whatever that could come back to bite us. And here's the party line. Here's the story we're telling. And now everybody's got to get on board with this story and tell the same lie, right? People think that might be over the top or hyperbole. Nonsense. That's exactly what this is. That's exactly what these is, okay? A lot of these big companies, most of these big companies, they lie their face off. They get caught doing shenanigans. Somebody calls them out dead to rights on racism, age discrimination, pregnancy discrimination, disability discrimination. And what do? Well, for a while there, before they button it down, there's a bunch of good evidence because that's honest, that's candid, that's real life unfolding right as it normally would. Then legal comes in, they put the clamps on it, now all of a sudden the story changes. Well, all that stuff from before legal came in, that is often Moneyball. And so you want to put that in your packet too, okay? This is basically compiling the inputs, okay? This is basically compiling the inputs. And some people, might be sitting over there and thinking like, oh man, this guy JP is terrible bald-headed jerk-faced meanie talking about people showing up with their trauma screed, and has he no heart? Has he no sympathy or empathy? Yeah, I got plenty of sympathy. I got plenty of empathy. Okay, I'm a good dude, and it's documented. I'm on the fucking record. Okay, but what I am not is I am not going to blow smoke up your ass. I'm not going to go out there and just tell people whatever they want to hear and glad hand people because I want to get some shit from them, or because I'm afraid of like them getting their feelings hurt. Like, no, like this is the real, okay? This is how you advocate for yourself. You put together the inputs in a way that is reasonable, efficient, accessible, okay? Well organized. And you give those inputs to your lawyer, okay? Let's talk about your lawyer, okay? I hate to be so brass tacks about this, folks, but in this particular area of law, there are good lawyers out there, okay? Let's start there. There are good lawyers out there. The problem is that in certain parts of the country, two things have happened. One, the courts have made it so difficult to pursue these types of cases that good lawyers who have other business, they have other cases, they have other options in the market. Because at the end of the day, like, look, right, like I do law my way, and a big part of doing it my way is I'm on a crusade. All right. Like, I didn't go to all y'all's schools and work at y'all's firms and be in y'all's boardrooms and, right, all the old timey shit y'all do, right? I got the same credentials. I got better credentials, right? I could run the power structure. I didn't go do that to become part of the power structure and push corrupt corporate paper and just make a bunch of dirty, corrupt corporate money. Actually, believe it or not, I got all those credentials and went that path so I could turn around and use it against you, right? And make a dent in the system because, one of the easiest knocks against anybody, right? Corporate America does this all the time. The power structure does this all the time where they're like, you're just jealous. You're just jealous that we're in the power structure over here. And they're not even in the power structure, okay? They're like, right? They're not like top 1%, top 2% in the power structure. They're literally, they are the servants of the power structure, okay? They're the ones who like got to run around and do whatever the power structure tells them to do, but they think they're going to get into the power structure. You're not getting into the power structure. You're not getting into the power structure, okay? You are the servants of the power structure. But one of the things that these folks like to do is they basically say, you're just jealous. You're just jealous that you didn't go to the schools we went to and you didn't work at the firms we worked at or at the companies we worked at. You don't have the credentials we have. You couldn't get into this exclusive ball game over here. Yeah, we're better than you. Well, Chet, I got news for you, okay? I got news for you, Chet. I graduated Phi Beta Kappa, magna cum laude from Cornell University. I went to law school at Georgetown where I was an editor of the Law Review. And I worked at an elite law firm, Boyce, Schiller, and Flexner, when it was literally top of the game in America, okay? So, in terms of these folks, okay, they might look kind of sideways at this, but like this is the reality, okay? Most lawyers don't want to pursue these types of cases because the landscape is so unfavorable. The federal courts in certain parts of the country, particularly in the South, particularly in Florida, have just botched the law on this. That's well documented, okay? That is well documented. There is a problem with courts granting summary judgment in the discrimination type cases, so discrimination, retaliation, sexual harassment, etc., hostile work environment. Basically, there are some cases from the past 20 years where courts have basically been like, the guy grabbed her breasts, but he only did it like 2 or 3 times. And so we don't think that was a hostile enough work environment. No, get out of here. Get shenanigans, okay? And that stuff is public, but it's public in only a technical sense. And that's a whole nother issue that I talk about, okay? That's why people are so afraid of me. That's why I got so much traction with what I'm working on, because the power structure, the system, big companies, insurance companies, a lot of big lawyers, corporate lawyers, they want to keep everything hush hush. They want to keep it all buttoned up, right? Yes, it's technically in court, so it's technically a matter of public record, but don't you dare talk about it, okay? And certainly don't be a guy with 85,000 followers on LinkedIn talking about it, because God forbid people would realize that the whole system is a dysfunctional mess, and sometimes it's even nakedly corrupt, and it's all a deck stacked against regular, poor, and working folks, right? That's America. That's the power structure. So, not surprisingly, there are these crazy cases out there, which have made it very hard for plaintiffs in these types of cases to get past summary judgment. And that's not how summary judgment works. That's not what Rule 56 says. Okay? If there are material facts, if there are significant facts in dispute, and a jury could come down either side of the case, then go to trial. That's how the law is supposed to work. But many courts, again, especially in the South, especially in Florida federal court, they have not been applying the law this way. They've just been saying, summary judgment granted, get out of here. Summary judgment granted, get out of here. That's not a case. I don't agree with that. I don't believe you. Summary judgment granted. Working on fixing that, okay? The 11th Circuit, which sits above, it's the appellate court that sits above Florida and certain other states in the South. The 11th Circuit is actually really fair and reasonable when it comes to summary judgment in employment discrimination cases. The 11th Circuit is like pretty clearly, staunchly against discrimination. They don't believe in cases that are like, right? Like if it's a trash case and it's bogus, like get out of here, sure. But like if it's a real case, if the facts are really in dispute, the 11th Circuit is going to pretty much tell you like, no, go to trial. Okay. And so that's part of the problem there, why so many lawyers, aren't going to aggressively pursue these types of cases. The other piece of the problem is that even when lawyers pursue these types of cases and are successful, either in the midterm, overcoming summary judgment, even at trial, the courts have put tremendous downward pressure on the rates and the fees that these attorneys can get paid. So at the end of the day, the juice is frequently not worth the squeeze, especially if you're a really good lawyer, right? Especially if you're a lawyer who has a thriving law firm, practice, business, and you have lots of other business, lots of other cases, including cases where people pay you a bunch of money. And who am I describing? Well, I'm describing yours truly, okay? Right now, we have paid cases. We don't just do contingency fee, plaintiff side discrimination cases. We have a lot of paid cases, too. We have big, huge, multi-million-dollar non-compete and trade secret cases we defend, where we make lots and lots of money off that, and we charge very high rates, okay? So for a lawyer like that, other than me, you're probably not messing with plaintiff side employment discrimination cases in a state like Florida, where one, it's an uphill battle. You're probably going to get bounced on summary judgment. And even if you prevail, you're not going to get paid enough money to make it worthwhile. So as a product of all of this, okay, people can't find a lawyer, all right? I hear from these people all the time. I hear from these people every day. They call our office. They send an inquiry, right? They've called, 3, 4, 5 places and nobody will take their case. Well, here you go, okay? If you called 5 places, call 10. If you have a real case, okay, you cannot be daunted. And now this is where stuff, falls apart and people have a difficult time understanding. Like, is there a possibility that you are delusional and you don't actually have a real case? Yeah, that's a possibility. But there's also a possibility that you do have a real case, okay? And now, look, again, right? That is going to result in like 50 people in the next 2 or 3 days contacting the firm and insisting that they have a real case when in fact they're probably delusional and they have no case at all. But nonetheless, okay, there will no doubt be in those people who reach out, there will no doubt be somebody who is the opposite, right? There will no doubt be somebody who does have a real case, okay? And they contacted multiple other attorneys, all right? And I'm not trying to give you false hope, okay? I'm not trying to sell false hope. I'm not a false hoper. That's not me. I'm not a sunshine, rainbows, puppy dog sort of person. I love puppy dogs, don't get me wrong. But I'm not telling you everything is sunshine, rainbows, and puppy dogs, because it's not, all right? This is the world. There's good and bad, okay? And the bad of it is maybe you're delusional and you don't have a real case. But the good of it is that you might have a real case, okay? And if you have watched a bunch of my videos and sort of read a number of the blog posts and articles that I have written, and that's not like because of my ego or anything like that. That's to say, like, if you have a pretty good sense of how I view these types of cases, the types of cases that we're going to select, the types of cases that we've litigated, and like, look, you can do your homework. There are a number of cases that we've litigated that are out there. They're publicly available. You can see copies of the complaint. You can look it up online, all right? If you do your homework, again, this goes back to advocating for yourself. If you do your homework and you look into the types of cases we do and sort of my general philosophy on these types of cases, you'll have a good sense of what I consider a real case. And so, yeah, some people will be delusional and they won't have a real case, but like there will inevitably be not just one, there will be several people who reach out and say, you know what? I contacted 2 or 3 or 4 or 5 lawyers, and they all turned me away. None of them were interested in my case. And I think I have a real case. And so would you please take a look at it? And anybody who reaches out in that way, I'm going to take a look at it, right? Like if they reach out correctly, okay, and they don't act entitled and they don't act ridiculous and they're not angry in this emotional firestorm, which frankly, I hate to just be real about it, but I don't have the time or the patience to deal with that, okay? But if they reach out correctly, and they're like a reasonable human being about it, yeah, I'll take a look. I'll see if you have a real case, because every week we accept somebody's case. We sign on somebody's case who has contacted 2, 3, 4, 5, 6, 7, 8 lawyers, and none of those lawyers have been willing to take the case. Or the lawyers have said, we'll take the case, but we're only going to handle it pre-suit. We're not willing to actually litigate the case. And that goes back to it being an uphill battle, the juice not being worth the squeeze in terms of the fees, et cetera, the ROI. And so if you're in that type of situation, right, if you've called one lawyer, call another. If you called 2, call 5. If you called 5, call 10. If you called 10, call 15, right? Call them all. Call them all. Call them all. And if you have a real case, the odds are that eventually you will come across, you will find, I hope, God willing, okay, and I put that out to the universe, that you will find an attorney who will be able to help you with your case. And if you follow my advice, you'll have put together basically an executive summary with the key documents and evidence. You'll be able to give that input to the lawyer, and you will be able to make that lawyer's job so much easier, help them get a clear picture of your case and your claims. And in doing that, you will be advancing your own cause. You'll be helping yourself, right? At the end of the day, that is one of the biggest things that I stand for, okay? Yes, I help a lot of people. Yes, I advocate for a lot of folks, and I think I'm a pretty good advocate, okay? I think I'm a pretty good lawyer, all right? And I think I get good results, and I help a lot of people, but you will always need to be your own advocate. And my goal at the end of the day is not just to stand up and advocate for people and fight for people and the causes I believe in, but is to lift everybody else up and teach other people how to advocate for themselves, how to stand up for themselves, how to protect their own rights, how to advance their own causes, and at the end of the day, how to empower themselves and how to give themselves a better life. Jonathan Pollard, happy Thursday.